Hi everyone, Jai Hind and welcome to the platform of StudyIQ IAS in English. My name is Bhavar Singh Surohi. I'm ex-NDA of 115th course and qualified civil services in 2012. Now in this session, we'll be talking about what is the actual proof of citizenship in India. But before that, let's talk about a story. Now this story is about Namgyal Dolkar. Now she was born in India and it was in 1986 that she was born to the Tibetan refugees. Now she had fought for her passport. The state had resisted giving her the passport, but the High Court, it ruled that the birth on the Indian soil between 1950 to 1987, that automatically grants the unconditional citizenship that is under the principle of jus soli. Now, this highlights the severe human cost of paper trails, the typos, and even the shifting legal timelines on the marginalized families that we are talking about. And yes, I'm talking about the recent, debate that have been started. Now, it is about the passport. Till now, it was considered that if you are holding a passport, the Indian passport, so this is the proof of citizenship. Now, during the annual Passport Seva Divas on 24th of June 2026, the Ministry of External Affairs have confirmed that an Indian passport is primarily a travel document and it does not establish any definitive citizenship under the law. Now, over here, this pertains to the Section 20 of the Passports Act 1967, which empowers the Government of India to issue the passport to non-citizens as well under the public interest. Alright, so that means the passport of India that could be issued to the non-citizens as well, and this creates a deep systemic conflict that is about the state's need for the strict border security as compared to the citizenship right for the existential belonging for the Indian citizens. Now, over here, we'll be talking about this in detail in our today's session. But at the same time, let me tell you that if you are preparing for the civil services for 2027, 28 or 29. So, we have the GS Foundation batches that actually builds your foundation, the principle that is very important for your selection in the the UPSC examination. Now, this is very important because these foundations are quite important to understand any of the core subjects that we are talking about. Like, for example, right now, I'm talking about citizenship. So, this pertains to part 2 of the Indian Constitution and we have the various articles which had been given over here. Alright, at the same time, we have the Citizenship Act of 1955 as well that pertains to the citizenship in India. It grants the various ways of how the citizenship can be granted to any person. Alright, so these are the foundations that I'm talking about. Now, you will learn these foundations in these batches and ultimately you can enroll into the Resolution P2I batch that is modeled upon the SMART framework where you get the structured classes, you get the mentorship, assessment, revision and even the test as well. And you can use the code that is BRS Live for the maximum discount on the platform of StudyIQ. Now, over here, this is when it comes to the citizenship in India. So, the citizenship can be acquired. This can be acquired through various means. Like, for example, the various methods which are provided under the Constitution and not under the Constitution, but under the Citizenship Act of 1955. So, there are total 5 means through which you can gain the citizenship. Now, the first way is by the birth. Or the second is by the, when you are born outside India by descent, you get the Indian citizenship. Then the third is by registration. The fourth way is by the process of naturalization. And we have the fifth process as well, that is by incorporation of the territory. So over here, there had been a remarkable shift when it comes to the citizenship by birth. And it was the jus soli concept that was there between 1950 to 1987. That is, there was absolute right of the soil. That is, if anyone had been born in India, irrespective of the parents that were there, so automatically he was granted the Indian citizenship or automatically he became the Indian citizenship regardless of any of the lineage that was there. Now, from 1987, there was an amendment that was done and there was the hybrid model that was utilized from 1987 to 2004. And this amendment, it mandated that at least one of the parent, it must be Indian citizen at the time of the birth, then you could be granted the Indian citizenship. Now, from 2004 to present, there is just sanguinis era that we are talking about. Now, just sanguinis era is about the lineage-based model and it is quite restrictive where one parent, it must be the Indian citizenship and it was laid down through the amendment in 2004 that the other parent or the other person must not be an illegal migrant at the time of the birth and that is how you can gain the Indian citizenship. And this is the modern era where there had been decoupled status audits. Ultimately, the extensive documentary proof is required to establish the ancestral lineage. And that is what we are talking about, the audit of the 2026 as well that we have seen in the SIR process, where the Supreme Court have said that for the purpose of the citizenship, that will be decided by the Ministry of Home Affairs. Now over here, when it comes to the various Indian IDs, you can see that we have lots of IDs and none of them actually constitutes direct documentary proof for the Indian citizenship. We have Aadhaar Card, which is the governing law for this is the Aadhaar Act of 2016. And ultimately, the legal purpose is for the targeted delivery of the welfare subsidies and even the services. And it is not a statutory citizenship proof. All right. And this was there was a key judicial precedent for the Aadhaar case that was laid down in 2017 in K.S. Puttaswamy case. Then there is voter ID, or that is the epic card that is there, which is granted by the Representation of People Act of 1951 and authorized or issued by the Election Commission of India. Now, over here, it authorizes the franchisee to vote in the general election, but at the same time, again, this is also not a proof of your Indian citizenship. All right, and the key judicial precedent was laid down in Lal Babu Hussain in 1995 verdict. Then there is passport, which is governed by the Passport Act of 1967, and it authorizes you for the foreign travel, the transit and the consular protection as well. Now, when it comes to the statutory citizenship proof of the passport, so this is presumptive and not conclusive. That had been said by the Ministry of the External Affairs that we have seen, and there is a precedent in 2013, that is Babu Abdul Sardar case, that you can go through it. All right, then we have the birth certificate that is actually provided by the Registration of Birth and Deaths Act of 1969, and they are for the factual proof or the factual record of the place and the date of the birth. And again, this is not the citizenship proof. It does not prove the lineage, and thereby when it comes to the complete rules that are there, they were drafted in 2003, the citizenship rule, and that is where you can find that birth certificate actually is not proof of the lineage that is there. So over here we have different IDs which are there, and ultimately over here this is very important when it comes to Section 9 of the Foreigners Act of 1946, because in the standard criminal jurisprudence that we will see in India, so it is whenever there is an accused, so he is innocent until proven guilty. And the burden of proof that lies on the state to prove that a person is guilty. But under the citizenship law or the disputes, the entire fundamental pillar of the jurisprudence, it is quite reversed. The burden is on the onus to prove that a person is citizen, that lies on the citizen himself or the person himself, and ultimately that is where you will find the reversal of the burden of proof when it comes to the citizenship disputes. Now, in the landmark judgment in Sabrananda Sonowal versus Union of India in 2005, the Supreme Court have reverted the burden of proof in the case of Assam back to the individual, and the court have characterized that unmonitored illegal migration is a form of external aggression, and it had legitimized the absolute state scrutiny as well. So there is the reversal of the burden of proof that we are talking about in the case of the citizenship dispute. Now, when it comes to the Constitution, I told you that it is the Part 2 that governs the constitutional, the principles of the citizenship. Now, when it comes to Article 5 to 8 that are given, so they actually governs the citizenship that was at the time of the commencement of the Constitution. There's Article 9 that actually provides that if you acquire or voluntarily acquire the citizenship of any other nation, so your citizenship, it will be taken away. That is, it provides that if we have the Indian law or the Constitution, we have the single citizenship that is there, and there is plenary power that has been provided to the Parliament for inaction of the law regulating the citizenship under Article 11. All right, and that is the legal source where the Parliament, it had enacted the Citizenship Act of 1955. Now, over here, it is very important that who governs your citizenship. Now, it is the Ministry of Home Affairs, that is the institutional framework which governs the Indian identity. And over here, you will find that the Indian identity or the institutional framework is quite fragmented as well. The apex sovereignty is Ministry of Home Affairs, but there are different ministries which issue the functional cards which are there. Now, like for example, Ministry of Home Affairs, it possesses exclusive sovereign authority over the naturalization, registration and even determination of the sovereignty. But there is RGI or the Registrar General of India, which operates under the Ministry of Home Affairs and act as the central coordinator for the national registers that are maintained, whether it is National Population Register or the National Register for the Citizen, and UIDAI and the Ministry of External Affairs. They are issuing the welfare cards or the welfare IDs like Aadhaar cards and the travel documents like, for example, passport under the separate laws which had been formulated by the Parliament. Now, over here, it is very important that what happens if there is identity denial. So, there is a structural domino effect that you will see. Now, first step is the document which had been rejected, and ultimately, if there is any typo in the lineage or there is missing birth register that is flagged by the local administrative officer, that will lead to the document registration, the rejection. And then there would be D-voter flag that will be levied. The individual, it is marked with a doubtful voter and the voting rights are frozen immediately later on. Now, this is in the case of Assam, but this may be in the case of the other states as well. Now, the third step is about tribunal summons, where the reference is routed to a foreigners tribunal, where the burden of the proof it actually rests with the citizen or the Indian citizen. And there is the fourth step, that is the social death. That is where the Aadhaar is suspended, the assets are frozen, and there is indefinite detention centers which await upon the failure. And ultimately, that is the cascading effect that we are talking about. Now, there are also sociological implications, because when it comes to India, we do not have a functional or the formal deportation treaty with the neighboring nations like, for example, Bangladesh. And consequently, if a person has been declared foreigner by the tribunal, so he cannot be deported. And this results into the prolonged, legally problematic and indefinite administrative detention. And this actually is very, very cruelsome for the marginalized vulnerabilities as well. Because the documentation burden, it falls highly disproportionately when it comes to the rural landless poor or the laborers, the nomads and the women as well. Because when it comes to these communities, they rarely have the secured land records. And in rural societies as well, the married women, they often lack the real or the local birth papers which are there that leave them completely vulnerable to the documentation audits in case their citizenship had been flagged by the local authorities. Now, we have the NPR as well. NPR or the National Population Register, it lists all usual residents of India and ultimately it represents the base data pool prior to the legal audits. Then we have NRC. That is the filter. Ultimately, NRC is National Register of Citizens that filters the residents to identify verified legal citizens and isolate undocumented migrants as well. And there is the safety wall. The safety wall was provided in 2019 when the Citizenship Act was amended, and over here it provided a fast-tracked pathway for the legal amnesty for prosecuted non-Muslim minorities which have non-Muslim minorities which have entered India from Afghanistan, Pakistan or Bangladesh, and that is the Constitutional Amendment Act of 2019. So there is this triad that we are talking about, which is where we have the contemporary landscape that operates as an integrated administrative pipeline which is designed to record, audit and regularize the Indian citizenship or Indian polity as well. Now, over here, when it comes to the global region or the global view, you can see that when it comes to India, so we have the dominant philosophy of the bloodline, that is just sanguineous, that is used for determination of the Indian citizenship. There is none of the standard national ID that is there, and there is complex document or lineage audit that is the primary proof of the citizenship, and ultimately there are poor historical records, the high exclusion margins, which is the systematic vulnerability that you can see in India. But at the same time, when it compares to US, so in US there is just solely or the territorial soil, or if somebody is born in US, he is granted the US citizenship. Over here also there is none of the ID card, which is basically the standard national ID. There are although SSN numbers which are they are issued, and there are driver's license which are used. Now, there are state issued birth certificates which are the primary proof of citizenship, and ultimately there are porous entry borders, there is undocumented labor tracking as well, which is a pertinent vulnerability when it comes to the United States of America. In France, there is civic and integrationist kind of the philosophy for the grant of the citizenship, and here we have they have the national identity card or CNI that is issued for the determination of the citizenship. Now, there is unified centralized civil registry and even intense social political assimilation pressures are there when it comes to the France as well. And then when it comes to GCC, so there is strict jus sanguinis, that is the bloodline that is used for the determination of the citizenship, and there is centralized biometric civil ID and even ethnic paternal pedigree registry that is maintained in the GCC nations. And over here that generates the permanent non-citizen class, that is again a system vulnerability that you will see in the GCC nations. Now, what is the roadmap for India? Now, it is very important when it comes to India. So, there is the future, or we can say the way ahead, that should be there. The first thing is that we should enact a statutory rule where the possession of multiple IDs or the verified state IDs which are there, that should shift the burden of proof back to the state, so that the state can prove any claims of the fraud, and it should not be on onus to the individuals. There should also be the unified citizenship card that should be there. Now, over here, we have to consolidate the identity registries into the single statutory national identity card that must be provided, and it must resolve the decoupled database crisis systematically in India. And there should be the independent tribunals. Right now, we have the executive-led foreigners tribunals that are there. We should replace them with the formal independent judicial tribunals or the bodies to secure the Article 21 right, that is for a fair trial that should be provided to the people in India. So that is what needs to be done when it comes to the documentation for proving your Indian citizenship. So that is all in today's session. I hope that now the complete session or the complete issue is clear to you. There is no clear ID that will grant you the status of the Indian citizenship. Also, when it comes to the complete problem, the problem is that ultimately it is about the audit system. It is about the lots of papers which are required for keeping the trail of the lineage as well. So that will be all in today's session. That will be all. So ultimately, please do not forget to like the session. Do share this session with your friends as well, and also do not forget to subscribe to our channel so that you do not miss any of the updates. And let me also once again revise that we have the GS Foundation batch in which you can enroll so that you can build the foundation for such kind of topics so that you can appear in your UPSC examination confidently. So that would be all. Thank you. Bye-bye. Take care and Jai Hind.